Good evening, and welcome to the public hearing on behalf of the Alabama Department of Environmental Management. My name is Christy Monk. I'm the designated hearing officer for these proceedings. The role of the hearing officer is limited to ensuring an orderly hearing so that an accurate record of this hearing may be developed for the department's evaluation. I do not make any decisions regarding these proposed permit actions. On behalf of the department, we appreciate your participation in tonight's joint hearing for the proposed issuance of air permit number 206-0051-X001 and National Pollutant Discharge Elimination System, or NPDES permit number AL00849191 for Creekwood Resources proposed granite quarry to be located on West Point Parkway, also known as U.S. Highway 29, approximately 0.6 miles east of Lee County Road 177, Opelika, Alabama 36804. The purpose of this hearing is to provide the public with an opportunity to present oral testimony on the proposed permit actions. In addition to oral testimony, the department will also consider all written comments submitted before the close of the public comment period. The department has requested your comments, and we appreciate you taking the time to make them known to us. On April 16th, notice of the date, time, place, and purpose of this hearing was posted on the department's website. In addition, the department sent notice of this hearing by email to individuals and organizations who had previously requested advance notice of permit proceedings. A copy of the notice and the email distribution list will be entered into the record of these proceedings. Copies of the public notice, permit applications, preliminary determinations, and draft permits have been made available for inspection by the public at the offices of the department at 1400 Coliseum Boulevard in Montgomery, as well as on the department's website. This hearing is open to the public, and anyone wishing to present oral testimony or submit a written statement may do so. Lengthy statements or those containing considerable technical or other complex data should be submitted in writing. Summaries of such statements may be presented orally. All testimony and written comments should be as factual as possible and should address the subject of this hearing. This hearing is an opportunity for members of the public to offer comments to ensure that all relevant factors are considered before a final permit decision is made. Please be advised that the department is limited in the factors it can consider when making permit decisions and must base the determinations only on whether the permit applicant has satisfied those requirements of applicable environmental statutes and regulations granted to ADEM by the legislature. Persons giving testimony may be questioned by the hearing officer or other department staff to clarify points and to develop a better understanding of what is being presented. This proceeding tonight is not an open forum, as in a question and answer session. This hearing is an opportunity for you to submit comments that you wish the department to consider in the final review of the permit applications. However, you may pose a comment in the form of a question, which will be compiled and addressed by the department in its complete response to comments. In addition to oral testimony, written comments may be submitted on the proposed permit actions. You do not have to make an oral statement tonight in order to have your written comments considered by the department. Written statements may be submitted to the hearing officer tonight or delivered to the department in Montgomery as directed in the notice for this hearing. All written statements previously submitted and those received by the department before the end of the public comment period will be included in the hearing record. It is important to note that written comments submitted through the postal or electronic mail are given the same consideration as those that are presented in person at this hearing. All oral and written testimony will be included in the hearing record. After giving full consideration to the hearing record, the department will make its final decisions on the proposed permit actions and develop responses to comments for the draft permits. The hearing record, final permit determinations, and responses to comments will be posted to the department's e-file system. This hearing is being captured by a court reporter to develop a transcript of this hearing for review by the department. In addition, the entire proceeding is being recorded on video to be posted in the department's YouTube channel to make it accessible to the public. Now let us move on to the purpose of this hearing, the receipt of public comments. The order of appearance of persons giving testimony will be as follows. First, a representative of the department's air division, then a representative of the department's water division, then a representative of Creekwood Resources, then any elected officials or their representatives who have registered to speak. All remaining members of the public will be heard in the order in which they registered during the pre-registration offered online or by phone, and then those that registered on site at this hearing. I now recognize Ms. Pam Hunt to present a statement on behalf of the department's air division.
Good evening. My name is Pam Hunt, and I manage the group that regulates permitting and enforcement activities for quarries for the Air Division of the Alabama Department of Environmental Management. I am here to present a statement on behalf of the department concerning the proposed issuance of air permit number 206-0051-X001 to Creekwood Resources, LLC. The department exercises authority under the Alabama Air Pollution Control Act and the Alabama Environmental Management Act to administer and enforce Alabama's air pollution control regulations. The department also has the authority to implement federal air pollution control regulations. Creekwood Resources, LLC is proposing to construct a facility that would involve the crushing, screening, and conveying of granite. These processes contain equipment that would be subject to federal new source performance standards. These regulations were developed by the U.S. Environmental Protection Agency and are uniformly applicable across the country. The department administers these regulations in Alabama. These regulations limit emissions of dust from crusher, screen, and conveyor transfer points. Dust from these processes would be controlled by wet suppression systems. The wet suppression systems that have been proposed for installation at this facility would be capable of meeting or exceeding all federal and state requirements found under these regulations. In addition, wet suppression systems would be used to minimize dust generated from vehicle traffic within the site. Any dust generated from the facility's operation would be in quantities that would define the facility as a minor source under state and federal air pollution permitting programs. Based upon our review of the permit application for this facility, the department has proposed the issuance of an air permit developed in accordance with applicable state and federal requirements. While the department understands that there are concerns surrounding the siting of a facility such as this, including traffic, noise, property values, and others, the department does not exercise zoning authority and may consider only comments relating to air quality in its final decision on this request for an air permit. The department has made a preliminary determination that compliance by Creekwood Resources, LLC with the conditions of the proposed air permit would not result in violations of applicable air quality standards designed to protect human health and the environment. This preliminary determination will be reconsidered after all comments are received and reviewed. Thank you.
I now recognize Ms. Angie Boatwright to present a statement on behalf of the department's water division.
Good evening. My name is Angie Boatwright, and I'm a Senior Environmental Engineering Specialist in the Mining and Natural Resource section of the Stormwater Management Branch in the Water Division of the Department of Environmental Management. The Mining and Natural Resource section regulates the permitting, compliance, and enforcement activities for the discharge of treated effluent from mining facilities within the state of Alabama. The department's water division is also represented this evening by James Carlson, Chief of the Stormwater Management Branch, and Ms. Catherine McNeil, Chief of the Mining and Natural Resource section. The department exercises authority under the Alabama Water Pollution Control Act and the Alabama Environmental Management Act to administer and enforce Alabama's water pollution control and water quality regulations. The department also has the authority to implement federal water pollution control regulations. The draft National Pollutant Discharge Elimination System, or NPDES, permit proposes authorization for discharges of treated effluent from the proposed granite mine and associated regulated activities through 3 proposed outfalls to waters of the state of Alabama identified as Halawakee Creek and an unnamed tributary to Halawakee Creek. Halawakee Creek and the unnamed tributary to Halawakee Creek are classified as being suitable for fish and wildlife. The discharges to Halawakee Creek occur upstream of Lake Harding, which is classified as being suitable for public water supply. Based upon review of the NPDES permit issuance application for this facility, the department has proposed to issue the NPDES permit, which was developed in accordance with applicable state and federal requirements, which are designed to be protective of water quality. The department understands that there are concerns surrounding the location of the facility and its proximity to Lake Harding and a residential subdivision. However, ADM does not exercise zoning authority and may only consider comments related to water quality in its final permitting decision. ADM's authority regarding mining operations is limited to the regulation of the discharges of treated effluent. The department does not have the authority to regulate the mining activity itself. The department has made a preliminary determination that compliance by Creekwood Resources LLC with the terms and conditions of the proposed NPDES permit will not result in violations of applicable state water quality standards designed to protect human health and the environment. This preliminary determination will be reconsidered after all comments are received and reviewed. Thank you.
I now recognize Mr. Major to present a statement on behalf of Creekwood Resources.
Good evening. My name is Jeff Major, Managing Member of Creekwood Resources. I appreciate the opportunity to directly address the permit applications we've submitted to ADM that are the subject of this hearing. First off, let me say that at Creekwood we feel that sustainability is the key to overall business success. Sustainability in terms of long-term, good-paying jobs in the community, being a good corporate citizen, providing quality building materials to support the growth of the communities we're in, and importantly, related to our topic here tonight, sustainability in terms of the sensitivity to the environment and being good stewards with respect to the water resources on and around the properties and the air quality we all depend on to survive. The products we produce are critically important to our way of life. No roads, bridges, public works, concrete block, or erosion control, etc. would be possible without it. Having good quality aggregate products available within a community also helps control the cost of construction within that community. Our proposed operation at Shady Grove will provide these much needed products to the eastern side of Lee County and beyond, providing a cost-effective source of building materials to support the continued growth. Shady Grove will directly create over 15 good quality, high-paying jobs for qualified individuals within the community, and will have a significant multiplier effect on jobs in local businesses, such as hardware stores, plumbing supplies, electrical supplies, tire suppliers, fencing suppliers, landscapers, paper products, mechanics, equipment rental suppliers, etc. Directly relevant to the subject of tonight's hearing, Shady Grove will use the latest technologies and best management practices to ensure that this operation will adhere to the strict guidelines and requirements as promulgated by ADM when it comes to dust control and stormwater management. We will work with the surrounding community to help preserve and protect the water resources related to Halawakee Creek and Lake Hardin. Years in the future, once mining on the site is completed, this property will be reclaimed into forest, wetlands, open water bodies, and wildlife habitats, all beneficial to the environment and ecosystem. As you're aware, on April 28th, we were issued our surface mining permit by the state of Alabama, and on May the 4th, we received our MSHA mine ID from the Mining Safety and Health Administration, designating the permit area as a permitted mine site. We look forward to continuing working with ADM to obtain the stormwater and air permits for this site and are available to answer any questions you may have. Thank you again for the opportunity to address you in this setting.
Thank you. We do not have any elected officials registered to speak at this time. Therefore, we will now proceed to the receipt of comments from members of the public. As indicated in the public notice for this hearing, oral testimony for each speaker is limited to 7 minutes. If anyone has prepared a statement that cannot be presented in a 7-minute time frame, please use your time for oral testimony to summarize your comments and submit your full statement to the department in writing for placement in the record. Right up here. And then just state your name and whether you represent any organization.
Okay. My name is Lynn Abernathy, and I'm representing Protect Beulah, and I live in Sentinel Hills. So, go ahead. I don't want to lose any time on the clock. I want to start out by saying that I worked very hard on trying to pull all of it together so that narrow grind that we have to make sure that you can talk about it, all fits together. So if you need to stop me, but if not, I'm trying to pull all of it to have something to do with land, water, and air. Okay, trust is a powerful 3-letter word that has not been fully established by any parties throughout this process, I feel. I know some of these questions are not technical from the permits, but when you remove the human factor and concerns for the well-being of your state's citizens, you lose all sense of civility. And without civility, I think there's anarchy. I hope you can restore my trust in the state of Alabama. I seriously doubt it right now, but in this format, very real citizens' concerns are not addressed, and we only get to be heard after you have issued a tentative permit. Who do we get to voice those concerns to, and do we? And what can we say at this point to change your minds? We were told from the beginning that finding historical sites, endangered species, or water issues were things that would stop the permit. And we have the historical sites, the Beans Mill. We have Shady Grove Historical Baptismal. We have the already impaired Halawaki Creek, which listed on your site in 2012. All those sites are around a mile from the quarry site. In regard to air and water, what are the effects of the silica dust and the other carcinogens that will be released into the air on humans, on wildlife, on vegetation, and our drinking water? According to reports, the Halawaki Creek was listed as impaired because it is not meeting state water quality criteria to support its designated use as a fish and wildlife habitat. Was a draft plan ever released establishing a limit on the amount of silt, sediment that can be discharged into the creek and still meet the state water quality standards? It was scheduled to release in 2020. If not, then how can daily minimum and maximum pH discharge limitations be included in the draft water permit? Part 1, page 4. Or are those just standard levels for all quarries in Alabama, regardless of the condition of the watershed supporting the quarries? How do we know when there is too much contamination and its effects on the water supply? How will we know when to report issues with air emissions? Does ADEM have a list of criteria so that citizens know how and when to report issues without having to go purchase equipment to monitor their own air and water qualities? I see the quarry has 3 basins planned for the property. In theory, silica and other discharge is supposed to settle in the bottom of the basin. Over time, how much discharge can settle before it starts flowing back into the creek or the stream it came from? And does that silica ever lose its potency? Are the basin's bottoms ever filtered or cleaned out to remove this buildup over time to further reduce the risk of water contamination? I was personally told by Creekwood that they would follow the vein of the granite wherever it takes them. Then I saw a flyer that states only 40 acres of the least 255 acres will be mined. My good guess, is that granite veins lead right into the Sentinel Hills subdivision, and at a later date with great expense to those living there. How can we, the citizens, feel good about trusting a company to self-report pollutants that emit into our air and water when they say one thing but appear to do the other? Does ADEM do surprise visits for monitoring, or do you rely on communities to form groups that could possibly put themselves in harm's way to gather information to report illegal dumping and emissions? And actually, Angie Boatwright told me on a phone call a month ago or so that we could form our own group, like the Chattahoochee River, Black Warrior River, or whatever, and we could do that. Has ADEM or the state of Alabama concluded any studies on the long-term effects of quarrying? What are the blasting effects to structures within a half mile? No, let's change that. I live a fourth of a mile. Half mile, a mile, 2 or 3 miles of new quarry versus older quarry. The reason I bring that up is in the 40s and the 50s and the 60s and the 70s, quarries were built everywhere. But they were built before the subdivisions came in and the retail came in and the churches came in. So they had a chance to get built without running the stuff that was already there. We own that land. We own the land. I own my house. And now we're having a fight for financial security and a place to live because it's a very real possibility that those things will falter. How does blasting and discharge affect people with PTSD, with asthma, with COPD, with Down syndrome, and other disabilities currently represented in the area? 5 of those things are represented by people who currently live in our subdivision, and children. What can we expect to feel or see, and at what magnitude when the quarry site starts operating will we feel ground tremors, foundation and wall cracks, ceiling trusses destroyed, and collapsed roofs? What are the effects of quarrying on septic pumps? Not septic tanks, y'all. Septic pumps. No one yet has been able to determine that because septic pumps are new. I just have to tell you, when the ground tremor hits it, my mother would roll over in her grave. Shit's gonna fly. Because nobody knows what's going to happen. The Shady Grove Quarry will backs up to our subdivision, other homes, churches, and businesses. We have had no choice. We've had no say in what will be a daily disruption of our lives and our financial security. This company has participated in 2 lawsuits against the Lee County Commission, trying to suppress the rights of citizens in Beat 13 to vote on zoning. And this is what they say. I read it tonight before I came in the room. We're going to be your best neighbors. Neighbors don't do that. Thank you very much.
Thank you.
Do you have a stapler or I don't have
a paper clip. Do you want to turn that in tonight? Or?
Might as well.
Okay.
Might be out of order. Thank you very much, y'all, for letting me respond.
Thank you.
Is Angie in here?
She's right here. Right here. Right here.
Thank you for talking to me, Angie. I know you probably wanted me to face to a name. Thank you very much.
Oh, ma'am, you can come up to the podium.
I was going to grab my notes.
Oh, okay. Oh, ma'am, you can come up to the podium.
Let me turn this off to hear as soon as they're here.
And you'll just state your name and any organization you represent.
My name is Elizabeth Borg, B-O-R-G. I'm an attorney and I represent Summer Lewis and Jerome Owsley. They are the property owners at 5304 Highway 29 North, Opelika. If that address sounds familiar to you, it is the address that was put on the ADM air application by Creekwood. My clients have been buying that property since 2014 on a lease purchase agreement, which basically amounts to a bond for title. Let me stop for a second. Is this Mr. Jeffrey Major?
No, he's not in the room.
Okay. I was going to ask him a question if he was. I made a copy of this for each of you. We have litigation about the piece of property that you have on the proposed quarry here in the Circuit Court of Lee County. We filed that litigation back in September of 2020. Initially, my clients were asking for a declaratory judgment from the property owner that they were buying it from, Mr. Teal. Since that time, we've amended the complaint twice. We've added in as defendants Highway 29 LLC and Creekwood LLC as well, Creekwood Properties. I'm going to be the only person that comes before you that says, you know, I don't need the whole 7 minutes, because this is pretty simple. There are a lot of things that are left up for discretion in making a decision about their permits. Someone's opinion, or a lot of people's opinion. But then again, there are those things that are what we call black letter law. They're the requirements that they absolutely must have before ADM can grant air or water permits. And probably that Misha wouldn't have accepted on the Misha permit, but that's another story. They have represented to you, it's my understanding, that the ownership of this land where they proposed this quarry is undisputed. And it couldn't be further from the truth. Like I said, we've had this in circuit court. It's in front of Judge Jacob Walker, the same judge who just turned down the litigation trying to stop the election. We have a scheduling conference that'll be coming up in a few weeks. And then the judge will set out a scheduling order. The defendants have asked for a jury trial. And jury trials obviously take a lot longer. But you know, it's their dime. And they're the ones that have asked for it. And I will, joined with them since then and said, fine, we're good for a jury trial. Because of COVID, there's a huge backlog in jury trials. And I don't know of a single jurisdiction who's sitting down to hear civil cases, no matter how important they are. They're going to hear all of the criminal cases because those folks have a constitutional right to a speedy trial, and because of COVID, they haven't had it. All those criminal cases will be heard in every jurisdiction that I know of before they ever set down a case like this for hearing. Sorry, my asthma's bothering me today. Normally, you can expect it to go through the pipeline for about a year from the time you get a scheduling order. I expect when we have a scheduling order, the judge talks to us about a trial date, it's going to be sometime next spring. And that's if we're lucky. And even then, we probably won't get to go unless the criminal cases have been settled. So I have attached to the brief comments that I've made here copies of our original lawsuit, copies of our first amended complaint that changed it from a declaratory judgment to a complaint for damages. Because my client's initial feeling was, let's just have the judge declare to look at it and say that we're correct about this and not ask for any damages. Now it's gotten to the point it's getting expensive. So we amended the complaint, added Creekwood Resources LLC. That was on December 18. And then we amended again and we added in Highway 29 LLC. The reason Highway 29 LLC was not entered initially is because when you go to the Alabama Secretary of State's page for corporations, when we filed the previous complaints, there was no such company listed as Highway 29 LLC in Alabama. I even called and talked with one of the assistants there to make sure that they hadn't received articles for this out-of-state corporation to do business in Alabama because I knew they were doing business in Alabama. They've been signing agreements and making deals, and gee, they even have a deed now. Of course, that deed that they presented to you wasn't granted to them until months and months and months after we filed the lawsuit. And believe it or not, they have actually presented a deed to ADAM to this property and maintained that there wasn't any question about their right to occupy this property and to build that quarry. When in fact, circuit court litigation has been ongoing the whole time, and that's pretty brave while the property is subject to litigation to go and sell it. Part of what they are taking or trying to take of my clients is part of their pond. And if they don't have planned to do any discharge into their pond, why would they have gone to such great trouble to get a survey done that cuts out a portion of my client's pond? They also want to take my client's driveway, a driveway that was included in what they're purchasing, that they have maintained since 2014, put up their own gate years ago, and now Creekwood put a big sign in front of my client's gate last week saying they had gotten their MISHA permit, Mine Health and Safety permit. I think it's amazing that they have presented this to y'all and are asking you to approve that spot at this location, knowing that someone else has a lease purchase agreement. It's written by hand. It's not fancy, but you know, it stands up in court just like a holographic will, you know, written by hand is sometimes even better than a will otherwise. Two more things. Neither Creekwood nor Highway 29 has filed anything in our litigation contrary to what we've claimed as far as any answer to the complaint. They haven't filed an answer denying the allegations on it. There are some motions that have been pending, but it's not even as if they are denying it, because we have flat out made the allege in front of Judge Walker. He knows that one of our claims is they're trying to take a portion of our client's acreage, including their driveway, and I knew you wouldn't have time to see video. The only place they could even cut a driveway to get to the road, they might as well be going across Europe in the Second World War. It'll take everything in the world to try and clear it, get out full-grown trees, dig out stumps, level it out. We're talking a good amount of money, plus they'll be emptying out onto a busier place at the road. And the last thing is this. I guess you've got a copy of the survey done on this in your packet. If you look at that survey, and from your viewpoint facing it, there's the original property of Mr. Teals, the property my client's about here, and the driveway comes right by what they purchased. Then there's a block, a square block, 90-degree angle block on the upper right of the plat. That belongs to some in-laws or step-in-laws, former relatives of my clients. If Creekwood were to be able and allowed to do this, it makes that piece of property landlocked. Creekwood never, and Mr. Teal is the owner of the property, or the seller, never, ever, ever went to put this in front of county commission and said, can I subdivide this land? Because I know that all of you know there is no planning commission and no county commission or city council that's going to allow something to be done that leaves somebody landlocked. So those are the last things I wanted to touch on. If you've got a question, I'll be glad to ask them, to answer anything you have. Were y'all aware before today that this property was the subject of litigation?
I mean, we can answer that in the...
Yeah, I'm just wondering. I didn't know if you were aware of it.
Yeah. Well, I mean, this is not a question and answer session.
I'm just saying, I'm just more curious than anything.
I mean,
I saw what looked like a plat that, in a deed that y'all were presented, and there was a statement made that it was undisputed, and that's why I'm asking, because it's most definitely disputed, and I'm just wondering if y'all had that information when you made a preliminary determination about the particulate or sediment and going into Hollowalker Creek, or any of the other decisions that you made tentative decisions on. I'm just wondering if you were aware when those decisions are being made that our clients who've lived and worked and been paying on this property are basically having it stolen from them. And that it is in litigation. Thank you.
You'll just state your name and whether you represent any organization.
I'm Lori Crevasse. No, I do not. All right. As a retired school or special education teacher, we were instructed to write IEPs in layman's terms and not technical terms so the general public could understand. Your own guidelines state our questions must address conditions of the draft permit, environmental laws, etc. And the majority of people whose lives...
I'm sorry, can you just talk a little bit slower so I can
Oh.
for the record?
I'm sorry.
Thank you, ma'am.
I'll leave a copy of it. That's fine. All right. Your own guidelines state that our questions must address conditions of the draft permit, environmental laws, etc. And the majority of people whose lives will be impacted by this quarry are not environmental lawyers, geologists, land surveyors, etc., who understand the technical terms used in these reports. Maybe I guess that's what the state of Alabama and the quarry companies are betting on so that they can impose destructive and dangerous operations on the tax-paying citizens of the state. I know that you are only following requirements mandated by this state. So in regards to the water permit, the wetland and stream evaluation conducted for Larry Speaks concluded by stating that there are 14 streams, 2 ponds, and a jurisdictional impoundment on the site. All streams were designated as somewhat stable. Does this designation have anything to do with the impaired status of the Halawaki Creek? Where can a copy of the total maximum daily load report that is required by law and was planned to be released in 2020 be found? Are the Beulah and Water Department and or the Opelika utilities prepared to keep our water supplied and clean in the wake of quarry development? The report also states constructional impacts to jurisdictional waters would require a permit from the United States Army Corps of Engineers. The report showed a preliminary application for this permit, but I could not find a granted permit on the USACE website. Is this permit granted before or after the ADEM permit? And does one permit take precedence over the other? Regarding the air permits, that's another one that I could not find the tentative air permit on the e-file from the ADEM website. So these questions may or not have been answered in that draft permit. But I was reading through some other quarry correspondence, and there was a Martin Marietta correspondence there where they had sent an email with a log, and they stated that their water truck was down, and they claimed they had the wrong email address and that they were trying to secure a rental. So a few days later, they had their truck working, but that led me to some questions. What happens when the log is late? How soon do they have to report down equipment? Do they get to continue operation of the quarry if they not have a water truck to carry out the wet suppression? If they get to continue with the operations without a water truck, how is the silica and other dangerous dust particles contained? And what are the consequences for violations of the guidelines permitted? A fine, a verbal warning, just what are the consequences? Another question is what happened to all the letters of opposition and inquiries that were submitted prior to the applications being filed by Creekwood Resources? The ones on the website appear to only be emails that were submitted after the applications. I was just wondering if those all got thrown out, if they were actually anything in there that was taken into consideration. So hopefully my questions will be answered. I don't know how I was supposed to prepare related questions to the draft air permit and the TMDL for the Halawaki Creek without the information, but I did the best I could to formulate technical and pertinent questions. Thank you for your time.
Thank you.
Do you get this paper or? Okay.
Thank you. Okay. And if you'll just state your name and any organization that you may represent, please.
I'm gonna set my timer so I know when to stop, because I tried to,
You have one more.
okay, I summarized 7 pages to 2, so I'm gonna do the best I can. Okay. Hello, ladies and gentlemen. Thank you for your time today. My name is Mary Kilgore, and I reside at 1969 Lee Road 177. According to their diagram, it says I'm a mile from the proposed quarry, but when I look at the documentation set, it said I'm less than a half a mile from the quarry. So it's kind of confusing how far it is. I have many concerns with both the air and water permits being requested. Not only will myself and my family be at risk, our entire community will be at risk. So please make sure all these risks are addressed before considering issuing these permits. First, I would like to address water quality permits. My first reading of the public hearing statement is very disturbing. The 3rd paragraph, 1st sentence, indicates authorization for discharges of treated effluent from the proposed granite mine. And everything I read in the pollution abatement plan, I did not see anything that indicated there was a filtering or treatment of water. All it says is it will be pumped in and out of the basins, and the water is to be discharged into our public water supply. Further review, I was reading the ADM Form 315, which is the actual application. There are several sections there that are also concerning. The multiple areas in the application where it clearly stated and is understood the discharge of effluent water will be within a mile into a public water supply, and the contamination of our Tier 2 water is possible. They also indicated that the economic or social development is more important, but I must strongly disagree. 15 to 20 jobs that may be created at this location is not worth the contamination to tens of thousands of people's water that is in our community. This water also supplies our school in Beulah. Our water will be receiving untreated liquid waste. Our waters are more important. Upon reading the NPDES permit draft, one of the main things that really flusters me is Part 1, Section A, is the discharge flow doesn't even seem to have a min or max, so it can just flow all day if it wants to. Even the perimeter of solids doesn't make much sense to me, because it says the monthly average is showing 15.50 mg per liter, but the daily maximum is 30. So how can the daily maximum be more than an average? That doesn't make any sense to me. In the spill prevention control and countermeasures plan, I see a discrepancy also. On page 25, it lists the Opelika Fire Department as our local fire department. This is not true. Our fire and water services are through Beulah Fire Department. This shows they are not consistent in providing correct information even before they receive any permits. On March the 13th, 2020, a letter was written by Jeffrey Major to withdraw their previous permit for quarry in another location in Lee County. In this letter, he indicated there would be no impact. However, the community's fear of such an occurrence is indeed very real. The previous location was less than 2 miles from Sagahatchee Lake, which is a public water supply. The current location is less than a half a mile from Halawaka Creek. So how can an occurrence not be a risk when it's even closer to a public water supply? It seems to me it's more of a risk. Now to address the air quality permit. There are 21 different processing operations noted in the application, and only one air pollution control device. How can one device prevent pollution from 21 different operations? Their permit also indicates their operation would be 10 hours per day, 5 days a week, 52 weeks per year. But if you keep reading, it says we can run 24 hours a day, 7 days a week, 52 weeks per year. That is every day. One of their things was we will not work on Sunday. Well, 7 days a week is Sunday. Pardon my expression, but that's a whole lot of dust being blown into somebody's face. How will these dust levels be kept down if they're running 24/7? Every emission point has a potential for fugitive dust also, due to the storage of the materials on site. This application also indicated the peak season is April through October. Everybody knows in Alabama, this is when we have droughts. In each of these 21 sites identified on there, it says emissions will be controlled by wet suppression using water stored in the basins. Well, I can tell you, during the hot summer days, there's many. We don't have rain, and there is no water. Where is this water supposed to come from? Because it's going to evaporate, because my pool evaporates, and I have to add water to it. So, also, they only require one person trained and certified in EPA Method 9 visual emissions. How can one person monitor 21 different operations? And I don't see any methods described to control fugitive dust when trucks are loaded on the premises. What are the restrictions on the minimum fill levels of these trucks? Are they required to have tarps over the materials? Who monitors that part? Everything I read on the document indicates they regulate themselves and will be required to report any failures. That seems absurd. My family, along with many of my neighbors, is against this quarry because of all the unknowns that can happen, and these regulations seem a bit vague. I find it hard to understand that they are to report themselves if they feel they do not meet the criteria in these requirements. The criteria is not strict enough to prevent endangerment of air and water within our community. I strongly urge you and your division to not allow these permits and stop this quarry from damaging our resources. Made it.
Thank you. You must have practiced.
2 or 3 times. And I ran over a couple times. So I have my full copy here, which I can email, and then I have my summary. Would you like those?
Yeah, you can leave them.
Okay. Do you get them?
Yeah, I'll make sure that it gets theirs.
Thank you so much.
Thank you.
Thank you. When does my 7 minutes start when I fall?
If you'll just state your name and any organization you represent for the record, please.
All right. My name is Naomi Rigby. I am a resident of Beat 13. I live in Sentinel Hills, which is encompassed by the proposed quarry site. It's right here. It's my towel of sand. Grain of that doesn't look very bad, right? We'll get to that in a minute. All right. So, in a pamphlet that was distributed by Creekwood, they had a photo, a picture. And on their website or their Facebook site, they also had a photo. And taking that and overlaying it with Google Maps, I'm an IT person, so that's something I kind of do. Apparently, they're going to be blasting approximately 2,000 feet from my front door. Now remember, they encompass us. That's an important fact. We'll go back to that in a minute. That's less than a half mile. Approximately 5.5 football fields. You guys football fans? Do you like going to the football games, Auburn, Alabama? Great. So, 5.5 football fields. Imagine the distance from Jordan Hare Stadium during an Auburn-Alabama game and 5.5 football fields away from there. I know for a fact that during most football games, but especially that one, 5.5 football fields away from there, you're gonna hear the noise. You're gonna hear all the effects. You're gonna hear the noise, you're gonna hear the sound, you're gonna see the things. And afterwards, there's tons of mess left over, right? Let's pause for just a minute. Imagine that. That's the sound. That's that explosion that we're going to be hearing near my house. Okay? 5.5 football fields away from Jordan-Hare Stadium in the middle of the game, you see all the effects. Afterwards, have you ever gone by the day after and see all the dirt and the nastiness that's left over? I mean, there's piles of crap, literally. You have the drunks, the beer cans, and you do have poo, literally, out there. The next day, you go, it's cleaned up, or it appears to be, right? Not really. There's stuff that's left behind. They don't clean it all up. Oh, but they work hard to clean it up, don't get me wrong. Just like Creekwood will work hard to clean their stuff up. But wait, there is a silent destructor. What is that? Well, there's a gradual buildup that a gradual buildup that silently grows over a period of time. No one knows it, no one sees it, no one hears it. But quite possibly the people near them do. We're near Creekwood. Over the years, there are going to be gradual effects to this community caused by this quarry if you approve their request. The destruction will be seen. Maybe not today, but it's that silent destruction that takes place that you won't see or hear until it happens. One might ask what a football game has to do with mining. Well, the hidden effects of all this comes together. During football, there's hidden rivalries. Over the years, many people take it to heart. They really believe in this. Auburn, their motto, believe. Their family. But over the years, there is environmental destruction. And how is that? First off, that trash that's left over, there is some buildup. And then the oak trees. Let's not forget the oak trees. It's the result of one silent, unseen individual that comes with natural or with years of animosity built up because of the competition that took place. Creekwood is that one fan to us. They will destroy our natural surroundings, and not only that, but our health, our tranquility, and like the bands, that tranquility go from nothing to the pans banging. Now they say it's going to be within regular working hours, but their regular working hours on their documentation, I hope I get longer than that, is literally says, it doesn't define their working hours. It does define it 24 hours a day, 7 days a week during peak needed times. So I'm going to go ahead and start reading this because I only have 2 minutes left. So immediately by destroying our tranquility like the fans and band in Jordan-Hare Stadium, slowly and steadily polluting the water we drink and the air we breathe. But no one will know, or will they? We will. We're the closest ones to them. No one will see, or will they? We will. We're the closest ones to them. No one will hear, we will, again, because we're the closest ones to them. The difference is the obstructor of the Oaks admitted to his crime. Creekwood will not. The obstructors of the Oak didn't have the funds to defend himself. Creekwood will. The obstructor of the Oaks was charged. Creekwood probably won't be. There's too many for you guys to manage. The obstruction the obstructor had to pay retribution. Creekwood, probably not. Neither will our insurance companies. In fact, they will rob us in the middle of the night. They will wait until our properties and homes are worthless. Then, for a lack of better terms, they will buy them for pennies on the dollar. I mean, their site literally surrounds and encompasses our neighborhood. Remember how close the blasting is? Well, they will have rights to portions of the land all around our neighborhood. Why buy now? Why can't they wait? They can wait claim it later for pennies on the dollar. That's good business sense, right? And I'm all for good business sense. I'm a native Kentuckian. I've seen firsthand the realizations of mining, the devastation to the environment, air, water, tranquility, and most of all, health of the people that surround it. I've watched it. I've watched it kill people. I know it's a different type of mining, but the effects are similar. Not to mention the destruction it causes in homes and the finances of those homes, or the finances of those in those homes. But who are we? Measly old citizens in a rural community that do not have a high-ranking official, the big-name individuals, the financial backing, or the location, because we're just a small community that the others have. Where our voices are not loud enough, not important enough to be heard. Our health and welfare is expandable. That's how we feel. But we are paying citizens. Our community does matter, at least to us. We do have a voice we're trying to raise. We pay you guys to protect us. We ask that you do that. We beg you to do that. Don't let us down. Don't tell us the little things. Don't tell us how little we mean to the state of Alabama by allowing outside companies and big money to come in and dictate. Don't approve their application. Tuesday night, the citizens of Bee County spoke. Today, I called and spoke to Cindy Thrasher and Robert Garrison. Garrison is the election manager. According to them, out of 651 registered voters that came in to vote, 431 of them voted for zoning in an effort to speak out against the quarry, how we don't want them there. That's 66.21% of those voters. Since 2014, there have only been 3 specialty votes and beat 13 outside general and primary elections. None of them outranked the amount or the percentage of people that showed up. In fact, the zoning vote turnout was more than double the runoff election in July of 2020, which was at 11%, and almost 3.5 more voters than in September of 2014 at 7%. And that was for a referendum.
Ma'am, are you almost finished?
I am.
Okay.
In closing,
Sorry.
I get it. Again, mining is big money. By the way, I forgot to do this as I talked. So imagine me putting in here 30 seconds, every 30 seconds. You can see through that water, right? Every 30 seconds I add more. That 30 seconds is every 10 years that they're quarrying. By the time it's finished, it's so murky you can't see through it. Imagine that being dirt, you drinking it. Do you want to drink that? I don't. Anyway, the sand on the ground, again, small little particles don't mean anything, but once they build up and add to a pile, that gets into your lungs, that gets into your air, it starts to mean something, especially to those of us who live there. U.S. mine production is $82 billion in minerals in 2020, according to Statistica.com. It's big money. I'm a money person too. I like to make a dollar, but not at the cost of other people's rights and humanities. Rumor has it that Chambers County is begging these guys to come there and mine. Let them mine. Let them go make their money there. Leave a community that doesn't want you. You've done it once. Do it again. Just because we don't have as many people in our area as they did, the majority of us still don't want them to be there. Leave. It's our life. It's our health. So health, welfare, noise, air pollutant. Imagine having $1 million on the line. Last example, and I'll let you go. Imagine. And I'm not saying Creekwood is a bad company. I'm saying they're out there to make their dollar, okay? And I get that. But imagine there's a line on the floor here. I don't know, I can't find a cord, but imagine the cord. Now imagine me being somebody, again, Creekwood's trying to make their dollar, and they're going to find every hole in the system to do that. Imagine that there's a hole in the fence here big enough for them to grab that money. $1 million on the other side. Within their reach. There are regulators out here who mean to do a good job, who want to do their good job, who work for the state or federal government, who are out there working hard to make sure that Creekwood doesn't stick their hand through that hole and get that money. But in fact,
They can't cover every mine, every situation that Creekwood has. They aren't out there as often. So they know that. So what's wrong with going over, taking that $1 million, pulling it back, making the money, causing the destruction, and then put that money back across the fence once they've made the money? Who wouldn't do that? Well, I wouldn't, because I'm an upright standing citizen. Not that they would or wouldn't, not that they are or not. Point being is, it's there. You pretty much know it's not going to be taken. They're going to reach out and do all they can to get that. So, in closing, again, I am a citizen. I live in the house that's in the middle of the quarry. They're all around us. This is my community. They're all around us. If the rock, the core, if the substance is all around us, you know it's got to be underneath us. And they're not going to pay for a house at prime cost while we're there. They're going to wait until they've started doing the destruction that silently starts to destruct our homes, our health, our livelihood, our sanctity, everything. Then, when those prices are as low as they can go, they're going to buy our homes for pennies on the dollar because they're not worth anything now. Then they're going to come in and mine the rest of the area. They can't do that. Oh, they could, but they won't do that now because it's going to cost them more money. Again, good business sense, not bad for it's not good for the community. And that's what I am. I'm that citizen. Thank you for allowing me to go over. Thank you for listening to my shenanigans, but I'm passionate about this because it's my life.
Don't forget to put your lid back on.
Thank you very much.
That could be a mess.
But I seriously beg you guys, consider everything. Health, noise, all the stuff that's important to us. Money's important, but nothing compared to our health. Oh, by the way, I asked a ton of questions because they said ask questions and we'll answer all your questions. I never once received an answer to any of my questions. Maybe they were too difficult, but never once received them. I have a copy of them here if you'd like to see them. I'll take that as yeah, because I don't need them. I got a copy of them. This email was sent on January 14th at 9:52, and it was sent to Creekwood at mail.com. It was sent to creekwoodresources@gmail.com. And like I said, I have nothing in return. And I'm sorry, I do not have 3 copies of it.
Oh, these are questions you asked Creekwood, not us.
That's correct.
Okay.
But they said they were going to be transparent and open and tell us and answer all of our questions. But again, so I didn't mean to upset you that bad. But again, that was for looks. And my point being is, if I'm here just for a dog and pony show so they can finish getting those requirements completed for you guys to give them that certificate, then I should have left when I first got here. Because to me it matters. I hope it does to you. All done?
No. I've got sandbags at home.
I do too. Imagine I'm getting you wrong. Was that mine?
Yes, sure.
I've been instructed that we don't have any more registered speakers. We're going to take a short break, about 10 minutes, to see if any other people show up requesting to speak. We'll be back in 10 minutes. Okay. We still do not have any registered speakers, so therefore please be advised that the public comment period will end at 5:00 p.m. Thursday, May 27th, 2021. All comments must be received in the offices of the department in Montgomery by that time. After consideration of all oral and written comments, the department will make its determinations regarding the proposed permit actions and prepare responses to all relevant comments received. Thank you for your participation this evening. This hearing is adjourned.